And I think that the home cultivation is going to go through the roof. You're going to see more and more patients seeking home cultivation and growing at home. This green rush is like the California gold rush. The miners didn't make the money. The shopkeepers did.
Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you.
My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law.
Pat, just real quick, just tell everybody watching who you are and where they can find you.
Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. This isn't a typical windshield time. This is just going to be a lead-in to an interview that I did with Nate from Nate on Cannabis this weekend. You know, he had some questions regarding the implementation and rollout of Missouri's medical marijuana. So we discussed that. We discussed the Sarcoxie lawsuit a little bit. And we discussed some of the other issues that we foresee coming up. That interview immediately follows this lead-in. So I will shut up now and you can get to the interview. Thank you and enjoy.
All right, so I wanted to get you on because the other day I dropped a video about the Sarcoxie lawsuit, and I just kind of touched the surface of what's going on there. And I wanted to invite somebody smarter than me to kind of explain to people what's going on and answer some of the questions I had. But before we get into that, I was wondering, how do you feel in general about the rollout of our medical marijuana program so far?
You know, it's DHSS is doing a fairly good job within the confines of the constitutional amendment that we passed. There are some decisions that were made in the amendment text that defy comprehension, like why this was given to DHSS instead of alcohol and tobacco, who have licensing schemes already in place and operate that on a daily basis. So we spun up an entire new division of state government for no reason when there was one that is already functioning, competent, has experience at exactly what we were doing. So I'm not really sure why we did that in the constitutional amendment, but within the confines of the amendment, DHSS is doing a fairly good job. They produced their emergency rules. They got the applications out on time. They actually got some of them out early. They've done a fairly good job in getting the patient's ID cards out and cultivation cards. So they're not doing bad. And if they trusted the MU report, they would have been horribly unprepared for what they faced. So I don't think anybody put any credence in the MU demand report that came out last year. So all in all, DHSS is doing fairly well, but they also collected a ton of money to gear up and get going with.
Yeah, 16 million, I believe. Is that right?
Yeah, it was about that. Everybody wanted to get their license pre-file. A lot of them pre-filed their apps before the final rules and the final guidelines came out to tell us what the ground rules of the game were going to be. And that's actually part of the basis of the lawsuit from Sarcoxie is.
Now, when the cultivation approval list came out, a lot of the companies seem to trace back to out-of-state companies, although we've only been able to trace back about half of the applicants. Is that something that you would have expected, so many out-of-state players coming in, or would you have expected less of those?
Yes, actually. At my firm, we assisted 4 companies in their license applications. And of those 4, the bulk of them are from out of state. They had in-state family members that were serving as the in-state component or a friend, but the bulk of the money behind almost all of these companies is coming from out of state. And part of the reason for that is because that's where the money is. People getting involved in medical marijuana are people that have been involved in hemp and cannabis in some way, shape, form, or fashion throughout the process. You're not getting a lot of really new people that just decided, hey, I'm going to seek a license and become a marijuana farmer next year. So the money is coming from out of state. Even supporting the local or the in-state applicants, they're getting their funding from out of state because they can't get loans.
So, in the Sarcoxie case, they are arguing that because the state awarded 30 to 40% bonuses for zip codes that had lower employment rates, like under 90%, I believe it is. So they're arguing that as well as the caps as being unconstitutional. I didn't really touch on the bonuses in my previous video, and I was wondering if you could kind of touch on that for us.
Right. Well, and those bonuses are an interpretation of the constitutional amendment made by DHSS. It is actually a very viable argument. Now, in the Sarcoxie case, they lost their request for TRO, and they should have. It wasn't a viable argument for TRO. Had they claimed that there was an upper limit cap instead of arguing that there was no cap, then they would have had a better ground for TRO because they wouldn't be able to be granted a license afterwards. There would have only been the block of 60. However, they're in worse shape for the cultivation than they are for dispensaries because there is a population component to cultivation licenses. Although I personally believe, based upon our most recent population numbers, there should be 62 cultivation licenses available on the per 100,000 population that we had discussed, as opposed to
Really?
60. Yes. But that's my evaluation of that. Now, they also allow for more licenses as needed. So the cultivation, if they can show a need, they can add more licenses. What that need may be, it's market demand. It could also be that DHS got caught and they're getting sued and they want to get out of it. So there is grounds for them to be able to add some licenses for cultivation. The market restraints that this creates, frankly, look, the constitutional amendment that we passed was written by people with ties to big business, and it supports big business. It's intended to. And most of the big business money is coming from out of state. So, because some of the in-state people are getting caught short. If you want to have a really interesting look at the licenses and licenses that were issued, okay, look at the numbers and you look at the point scoring for licenses, and I'm sure you already have. You have two firms that were denied licenses despite their points being within the approved parameters. Basically, everyone that scored over, I think it was like 1490 and up, was approved, except for two companies.
What happened there?
And that's the question. What happened there? We don't know. They were denied. So with that, we can't say why they were denied, just that they were. And we can talk to those companies and try and find out, but they may or may not tell us. One thing I'm wanting to do, working on, is correlating the approved licenses with the scoring sheets. When you look at the scoring sheets that have been released, on the scoring sheet, you have the final number. For example, 1194.93. We can go from that score sheet, which is not labeled as to which company it was, but using that final score, and we go over to the license approval and rejection form, and you can scroll down, you can find that 1194.93 and see what company that was. And then you can also look at the scores. Like question number 1 was, proof of good character for the principals and the managers, up to 3 pages per person. That had a maximum point value of 10 points. The company I just mentioned, the 1194.93, only scored 7 in that category. So they missed 3 points there. And those you would think would be easy points to get. So they didn't show good character for all of their people as fully as someone else did, or whatever the individual scoring criteria for that question was. And that's what we need to get. Okay, there needs to be a sunshine request for what the scoring criteria that the scorers are using for each individual questions. But somebody's going to have to make a sunshine request for these scoring criteria that was sent to these scorers as to how they were supposed to score things. How do you score question number 1? What is the point basis? If it's arbitrary, you know, well, I'm going to give this one a 7, then that raises serious questions as to whether or not those were scored the same across the board if they had different scorers. You see where I'm going? Then it becomes an arbitrary assessment of points instead of a scored points. And there's an argument there for somebody who was denied. The Sarcoxie case, look, the Calicoats have been involved in attempting to get medical marijuana for quite some time. Yes, they had personal motivations and intended to make a significant amount of money, and you know, God bless them, we all want to make money. But their suit has merit. It's going to be a groundbreaking suit. It's going to go to the Missouri Supreme Court eventually. But what it's not going to be for a year or two, and you know, the market's going to be pretty well defined by the time they actually get a license.
So you think it's, do you think it's kind of all for naught, or do you think it's something worth still pursuing?
You know, it's that kind of thing is worth pursuing because we have to hold the state accountable, and the only way you do that is through the court or the ballot box. As far as for not, probably not. Look, we've approved medical marijuana, it's rolling out, and we have some issues with that, not necessarily with DHSS, but with the state law enforcement and judicial system is having issues with that. But we are on track for full legalization. Okay, it's not a question of if, it's when. It's going to happen. So is there pressing the suit on the medical marijuana? Is that going to help move towards full legalization? Is it going to hurt the move towards full legalization? Is it going to position them better or worse when that happens? They might spend a lot of money fighting that, but then turn around and be in a prime position for full legalization, and they can reap those benefits. Or, you know, I mean, it's an expense. They are entertaining expense, and I'm sure that they sat down with their lawyers and discussed the likelihood of success and whether or not the investment in litigation was likely to be a good investment or not. Look, a license to grow marijuana is literally a license to grow money.
So the judge in the case the other day said that because the Constitution sets a minimum, that it contemplates limits and caps. Is that kind of a hint towards what future litigation may hold as far as lifting the caps on the approvals? That because it was in the Constitution as a minimum, that the Constitution itself allows for caps and limits?
You know, there is an argument that, and that's a fair reading and a fair assessment. However, there's also a maximum law that says that the inclusion of one is the exclusion of others. So if I include a minimum and I don't include a maximum, there's an argument that there is no maximum. All we have set is a minimum level. You know, and when we have a maximum and we don't set a minimum, there's an argument there is no minimum. Let's take speed limits, for example. Okay, we have a speed limit of 35 miles an hour on the street in front of my office, but there is no minimum speed limit on the street in front of my office. You can drive down that street at 2 miles an hour if you choose to. If I'm behind you, I'll be screaming obscenities the whole way, but you can drive 2 miles an hour. Just because one has been included, that does not mean that the other is automatic.
So are you hopeful for the rest of the rollout of our medical marijuana program? And when you foresee dispensaries is open? Do you see them opening on the same timeline that everybody's already been predicting, mid 2020, or do you think this delays the entire program?
This suit isn't going to delay that. This suit is dealing solely with Sarcoxie Nursery and whether or not they will receive a license at the end of it. It's not going to disrupt any of the other rollout. If they receive a license, it will be an additional license. They're not going to shut anybody else down. They could have.
If they win their suit, it doesn't open the door for everybody else to jump in and reconsider their denials.
Oh, it will open the door for other lawsuits, but that's not going to affect the rollout. The time to file suit and seek an injunction barring DHSS from issuing any licenses is really getting past because the licenses are being issued. Now, and you have to remember, the licenses we're talking about are conditional licenses. These aren't the final licenses. They're conditional. All the companies that have their license that was awarded to them for cultivation now have to do all their build out, meet all of their regulations that they have to meet, and have a final inspection. And their license will not be a full license until the final inspection. I would expect that we're probably going to lose anywhere from 3 to 6% of the people who are licensed conditionally are going to lose out because they don't get everything done. We were talking about this a year ago, that these companies have to have solid financial planning. I met with a few. We have on our team that we did licensing for, we have MBAs and, solid business people that have run multi-million-dollar businesses. But when we were talking to the people, they weren't prepared for those expenses. They weren't prepared for the regulation expense in getting open. And that's something they had to be ready for, and they had to have the resources to draw on. And sadly, $1 million in the bank isn't getting you open on a cultivation facility. And the problem with that is you can't finance it.
That is true. So they can't get any kind of bank loans to raise the capital to start these businesses. It's all got to be friends, family, and cash.
Pretty much. Some of these corporations are financing through equity, which means they're selling shares in the corporation. But marijuana being Schedule 1 is still illegal federally. So any nationally licensed bank is not going to loan you money on that. They can't. They're endangering themselves with banking regulations. Now, the Safe Banking Act has passed the House, passed the committee. It needs to be fully passed out of the House into the Senate. Hopefully it'll get approval and then go up and be signed. But when the Safe Banking Act passes, then banks will be able to open accounts for marijuana companies, marijuana-related industry, and they'll be able to start loaning on it. But right now, if the bank touches you, they're at risk of being shut down.
So my last question to you, Pat, is do you foresee any other lawsuits before the Sarcoxie suit comes to a close, or do you think if there's going to be lawsuits, people are going to wait or jump in now?
I'm actually really surprised that there hasn't been a poison pill lawsuit filed. Our constitutional amendment calls for in-state ownership. 51% owned by a Missouri resident. Now, some of these companies have tried to skate through that with LLC structures, and you've seen that, and I'm sure you've looked at that. Mm-hmm. Some of those are going to have issues when they actually explore the ownership of the LLCs. But the in-state ownership requirement violates the Dormant Commerce Clause of the United States Constitution. You can't do that. Okay, we have cases out of Tennessee recently, cases out of Kentucky, dealing with alcohol and bar ownership, where they said it has to be owned by an in-state resident, or you had to been an in-state resident for 2 years before you can get a liquor license, and that is not constitutional. You can't keep the other out. So, if I'm surprised that one of the anti-marijuana groups hasn't gotten somebody from outside the state and sought a license just so they could file suit, seek an injunction, and shut the whole damn thing down while it was in federal court for 3 years. Well, we're at the point now where if they haven't applied for license and they haven't been rejected for that reason, they're too late. As far as getting injunctions and blocking. Right. I mean, the license application time is over, so it would only be somebody that has already applied.
Okay.
And if they applied and spent that money and didn't went through the application process, then they better have had 51% or they got cut out right at the very beginning. But I'm really surprised that that lawsuit hasn't been filed. The out-of-state ownership is one that I think is ripe for suit on. And if I was the one filing it, I would seek an injunction and I would bar them from issuing any licenses. And part of the reason for that is, let's take cultivation. You have 60 cultivation licenses, okay, that they've approved. They're issuing 60. So if they've issued 60, I don't get mine and I'm suing. Those 60 plants get up and running, they're functioning. Now, if I'm given license number 61, my license has been diminished because there is an extra plant producing marijuana, which is going to drive the supply up and the profit down. The same thing, all the other 60 license holders, all of their value has been diminished because there is an extra licensee that is going to be producing marijuana, driving their value down, increasing the market supply, which is going to reduce the price. That is theoretically good for consumers. It's bad when you've got bottom line and investors to pay. What you would do when you have a limited number of licenses is you would freeze them and say nobody gets a license until we resolve this. Okay, that would be a temporary restraining order that very well could have been ordered. And Sarcoxie, they didn't do that because part of their argument is that there is no upper limit on the licenses. And if there isn't an upper limit, then that argument fails.
Do you think that when the other licenses, dispensary licenses and manufacturing licenses come out, that's going to be as rough a rollout as these were? Or do you think that's going to go a lot smoother than the cultivation licenses? Because in my opinion, cultivation is the heart of the program in Missouri if you're in the business at all. It's where it all starts.
I think, quite frankly, that the people that are investing millions of dollars are making a mistake. There's going to be.
What do you mean by that?
Well, there's going to be money made in cultivation dispensaries, but it's not going to be as much as they think. Look, the bottom line here is that the cost of operating a dispensary and operating a cultivation facility is going to require, and the regulation is ridiculous, but it's going to require that the cost of the marijuana from those places be obscenely high. And the reality is, you're not going out, and I'm going to date myself, you're not going out and buying a dime bag and then paying $300 for it. It ain't going to happen. Okay, the people that are actually going to be relying on this medicine aren't going to be able to afford some of the prices that it's going to be at. So
you think it's going to be a high as far as national average?
Yeah, it's going to be pretty high. I've seen some price projections that I looked at and I'm like, you realize you're not going to get that in a rural area. It's not going to happen. People are going to continue with the black market because it's affordable. This isn't going to eliminate the black market, and it's not going to eliminate. I think what you're going to see is some initial price shock. People will pay it. Some people will pay it, and it'll be enough to keep the businesses open, but not as wildly profitable as everybody imagined going in. They'll be profitable, but they're not going to be ridiculous. And I think that the home cultivation is going to go through the roof. You're going to see more and more patients seeking home cultivation and growing at home. Yeah. So really, this is like any gold rush, man. This green rush is like the California gold rush. The miners didn't make the money. The shopkeepers did. The home hydroponics suppliers, the people that are going to teach somebody how to grow at home. Right now, you've got meetup groups popping up all around Missouri for home growers. What they need to know, where they can get supplies. You're going to see small hydroponics suppliers, small home grow suppliers all over the country in every community. That's the small business that's going to make a lot of money in marijuana in Missouri. It's going to be the people that are going to be able to provide you with a hydroponic setup, tell you how to set it up, and then supply you with all the chemicals that you need going forward. That's where the regular money is going to be made. And people are going to buy their initial seeds from the dispensary once we have the seed to sale tracking. And that'll happen. But how we recover from the Immaculate Conception for seeds to require regulated seeds, that's going to be one hell of a transition. I'm not sure how they're going to manage that. Are they automatically going to say one day that your grow is now illegal because you don't have the seeds from that grow didn't come from the dispensary? I think they're going to have problems with that.
I hope not, sir. I appreciate your time, though. We kind of ended it on a high note. I'm glad that you are predicting that home grow is going to be the future of Missouri, and that small business is where we need to be at. I want to thank you for your time, man, and appreciate it.
No, not a problem. Before you go, I want to say thank you to you. Your work with Jamie's case over the western part of the state there, getting attention to it, has been phenomenal. That's the kind of support that people need, especially right now when law enforcement's trying to read phrases into the law that don't exist.
What do you mean by that?
Well, and it might wind up being a separate conversation we should have at some point, but
Okay.
Right now you have a right to possess medical marijuana if you're a card holder. The Constitution and DHSS have not said that you have to buy that medical marijuana from a licensed dispensary. There aren't any to provide it to you. They've issued cultivation cards and they've issued patient ID cards, and the Constitution is clear that you have a right to possess medical marijuana. It doesn't say that you have to get it from an approved source. So you have people that are being charged criminally with possession because police are attempting to read a requirement to get that from an approved dispensary into the law, and you can't do that. Those cases are all going to be, in my opinion, resolved in favor of the defendants, but it's one of those classic things, man. You can beat the rap, but you can't beat the ride.
Yeah, that's true. Yeah, hopefully they get their act together, because cases like Jamie's, where he's facing some pretty big charges for being what I and a lot of people believe is within his right to possess those 8 ounces, even though that might seem like a lot to some people. The law allows it, and he had it. So I really hope that as we get closer into the year, that law enforcement and prosecution and even the department itself needs to step up and educate.
They should, and people should follow these cases and stay aware. And that's something that you've been doing on Facebook and on your channel, and is eminently valuable. Communicating to the public so that they're aware and they take action, going down, protesting, talking to your elected officials, talking to your police departments, your sheriffs. Those are all key to getting the generalized acceptance that we need of the changes in the law. At some point, the powers that be are going to understand that the situation has changed and they have to adapt. Hopefully we can get there with
You hear that? You have to adapt, DHS.
Well, I was actually referencing Missouri Highway Patrol, but yeah.
Yeah.
And you'll notice that those cases, like Jamie's, are occurring in certain areas. They're not occurring in
rural areas.
Jackson County. They're occurring in an area where they think that the prosecutor is going to go with them and they can push this, where they think that they're going to get the judges, they're going to rule with them. And then try to frame the question for the Court of Appeals. So they're pushing that in a certain area, and the Highway Patrol is not doing that across the board in every county. So that tells me that that is specific and intentional. If it was a true highway,
Wow, that is
if it was a true
disturbing.
highway patrol policy, they would be doing it across the board. But they're not making those arrests in my county.
They're making them in mine. Thank you, Pat. Man, I have to have you come back on and explain smart stuff to dumb people like me. I really appreciate it.
Well, I can try, but there are a lot smarter people out there than me, man. All right.
All right, thank you. I'll talk to you soon.